Okay, everyone, thank you very much for coming to today's Current Affairs Forum. The topic today is on LGBTI refugees in the EU Asylum System. So we'll feature research from Denise Venturi, who's from the Institute of Law, Politics and Development at the Sant'Anna School of Advanced Studies in Pisa. So I'll just hand over to you.
Okay.
And
thank you. Okay, thanks a lot to everybody, and I will first introduce a bit myself, what I'm doing, my research, and basically at what point I am in my research. So as Patrick said, I am PhD candidate at Scuola Sant'Anna in Pisa. It's a very small university in Italy. Our program is Politics, Human Rights and Sustainability, and it's supposed to be a multidisciplinary program. My research area is international law. And at the same time, I'm doing a joint doctoral program with KU Leuven in Belgium, and there it's a PhD in law. So what I'm presenting today is my research project, so I will take a bit of a step back on what I'm doing at the moment in order to get suggestions and feedback from you, and also because our research is like always a work in progress, and at a certain moment you need to think about what you're doing and at what point you are. So before starting, I would like to let you know that this is the project how it is now. It's the results of, let's say, many let's say change on it. It started as a broader project which was supposed to analyze the use of the body as an instrument of border control in the European Union, and LGBTI asylum seeker was supposed to be one of the cases that I would have to take into account. Then I realized that I have only 3 years, not a lifetime, to the PhD, so I narrowed it down a bit. So what I would like to go through today with my presentation is to provide you with some preliminary remarks and background on the topic of the research. I will explore the aim of my research. I will explain the methodology that I'm using. I will give you like a bit of hints on the theoretical framework, which is again one thing that I'm still working on. I will explain you what I am so far with my research, and then I will put out some open issues that I'm still debating with, and then I hope that we can discuss on that and get your comment about this. So a bit of summary on the research. This project focuses, as Patrick said, on LGBTI asylum seekers with a particular reference to the European Union. The reason why I'm focusing on the European Union is mainly because of my background. I've been working as a lawyer in Italy before. I've been dealing with criminal law and immigration and asylum law, and so the EU is something like familiar to me. Besides this, I think that this is a topic that is not well researched at European Union level. It's a topic that is gaining more and more attention, as we can see from the research that are currently going on. And also, for example, yesterday, the Intergroup on LGBT Rights of the European Parliament organized an event on LGBT asylum seekers, how to protect them, especially in the context of the current refugee situation. Specifically, my project looks at how the law of evidence, and I will explain later what I mean by the law of evidence, is framed and implemented in sexuality-based asylum claims. Moreover, it aims to explore the human rights implications of evidence assessment. And finally, it seeks to discuss the research findings within the context of the Common European Asylum System. So in this part, I will try also to go beyond the topic of LGBTI asylum seekers. Another thing that I try to investigate with my research is the paradox of evidence, especially in the context of sexuality-based asylum claims. Now, what I mean by paradox of evidence is that evidence in an asylum claim, but generally in like a judicial trial, a judicial situation, is on the one hand what states need in order to assess whether an asylum claim is sounded, is well supported, and when the person is in need of international protection. On the other hand, evidence serves to support the person's account to be protected against refoulement. So it may not seem like a paradox, but if you think about it, and if you think about the role that evidence plays in the context of asylum claims, I think it's absolutely crucial. What I mean by paradox is that evidence can serve two interests that can be competing sometimes. So on the one hand, as I said, the interest of the state, on the other hand, the interest of the person to be granted protection. The research unfolds according to three levels of analysis, and I will explain them while I progress with the presentation: the international level, the European level, and the national level. So just to give you some, let's say, again, remarks and background on the research, maybe you're all familiar with these terms, but basically what I mean by LGBTI asylum seekers are lesbian, gay, bisexual, transgender, and intersex. So basically, people who apply for asylum for persecution based on their sexual orientation and gender identity. The concept of gender identity and sexual orientation, as you can read, so I won't repeat that. I refer to the European Charter Principle of 2016. There are principles on the application of international law or international human rights law to sexual orientation and gender identity. These are principles developed by a body of experts on this topic, and of course they are soft law, so they're not binding, but they nevertheless give an authoritative interpretation of international human rights law in this context. Instead, as I said before, what I mean by the law of evidence is the rules and the legal principles governing the proof of facts in a legal proceeding. An evidence assessment is understood as the process of gathering relevant information on the situation of the applicant, examining it, and eventually deciding upon the request for international protection. In my project, I break down the concept of law of evidence in 4 elements. So the burden of proof, meaning the obligation to prove the claim, the standard of proof, the threshold that has to be met in order to persuade the decision maker on the decision, the types of evidence that the claimant is bringing in order to support his or her claim, and finally the concept of credibility, meaning that the statement of the applicant will be checked against all the other evidence that is available to the decision maker. So again, when in the presentation we refer to the law of evidence, I mean these 4, let's say, elements. To give you a bit of legislative framework and an idea of the topic, as you may know, in the context of the Refugee Convention, International Refugee Law, sexual orientation and gender identity are not included among the grounds of persecution by the Refugee Convention. But typically, these kind of claims have been accepted by falling under the membership of a particular social group ground. And also this approach has been developed by courts, and also this has been let's say, endorsed, also reiterated by UNHCR in 2012 in the guidelines of international protection on claims based on sexual orientation and gender identity. Some scholars claim that the PSG ground is not the only ground that we should look at when we talk about claims based on sexual orientation and gender identity. For example, also the grounds of religion should be explored, as well as the political opinion one. Moreover, some scholars have claimed that sexual orientation and gender identity should be instead looked as a ground of persecution per se. Regarding EU law, instead, sexual orientation and gender identity features in the Qualification Directive in Article 10, Paragraph 1, letter D. The directive says that sexual orientation and gender identity are elements upon which a particular social group can be identified. However, as you may already be aware of, the qualification directives requires a cumulative approach as for the identification of a particular social group, because it requires the simultaneous satisfaction of the particular of the protected characteristic test and the social perception one, differently from what UNHCR recommends and what is the interpretation of the UNHCR. Now, in the presentation, I won't go into these legal issues because my purpose today is more to get, again, feedback and comments on the project, but we can then, of course, discuss on this. Regarding instead evidence assessment, as I said before, the rules on burden of proof and standard of proof are crucial when it comes to the outcome of an asylum application. And previous research on this topic showed how LGBT applicants face challenges and hurdles in proving their claim. The Court of Justice in 2014 gave, let's say, some sort of guidance on how to assess LGBTI asylum claims, but it was more, let's say, a not to-do list rather than a to-do list. So it didn't provide authorities with clear guidance on what should be taken into account when assessing this kind of claims. Finally, the European Asylum Support Office in 2015 issued a tool on evidence assessment, underlying how it is important for the purpose of the Common European Asylum System to have similar, let's say, standards and concepts when it comes to evidence assessment. As you can read from the slides, in fact, according to the European Agency or the European Union Agency, member states apply similar legal concepts regarding eligibility for international protection, but if their appreciation of evidence is different, they may easily reach different conclusions, and this may, let's say, hinder the concept and the purposes of a common European asylum system. Now, regarding the relevance of the research, I was a little bit puzzled of whether to include a part on why researching on this topic is important, because the reason why I decided to do that is sometimes I've been asked, why are you focusing on LGBTI asylum seekers if you consider the current refugee situation in Europe? They are just a minimum part of people coming into Europe. There are not also reliable statistics on the exact number of LGBTI claimants. So I'm not trying to find a sort of justification on why we are researching on this topic. I will just explain why, in my opinion, it's important to focus on this topic. First of all, from a human rights point of view, LGBTI people are exposed to a wide range of human rights violations all over the world. Also in that is considered the first world as Europe and so on. I come from a country, Italy, which doesn't have any LGBTI-friendly legislation so far. We are just in the process of adopting a bill on same-sex civil partnership that you cannot call marriage. And it's still in the process of being approved. According to reports by the International Lesbian and Gay Association of 2015, 75 countries in the world criminalize same-sex conduct, and 5 of them apply death penalty. However, according to other research, I'm sorry that maybe it's not easily readable from the slide, but basically according to the Erasing 76 Crimes blog, this number should be updated to 79 countries. Because also of non-state actors like the Islamic State that is persecuting LGBTI people, or people, let's say, accused to be homosexual. Moreover, people who challenge the sexually constructed nature of gender roles are forced to flee because of this human rights violation, because they are not safe in their country of origins. From instead a human right, from an academic point of view, instead, no exhaustive research has been carried out yet, especially at EU level. There is one important research, which is a bit of the landmark research in this field for what concerns the European Union, which is the report by Professor Speaker Boer of 2011. Then it was also transposed in an edited volume in 2013, which is the report Fleeing Homophobia. It's a good work, a good report, but it lacks of an academic, let's say, framework. It doesn't have a theoretical framework. Moreover, previous studies in this field focused only on credibility and not on evidence assessment as a whole, as I tried to explain before. For what concerns instead evidence, recent studies have dealt with this topic and with the topic especially of the law of evidence and asylum. For example, Staffans in 2012. but again, from a more general point of view. So what I'm trying to do with my research is to put together scholarship on LGBTI asylum seekers on the one hand, and on the other hand, scholarship on the law of evidence in the context of asylum claims. The aim of the research, as I also explained before, is to contribute to the debate on LGBTI asylum claims in the EU by offering a new theoretical and empirical perspective, as I think every PhD project aims to do, on a specific issue of the law of evidence. I would like to carry out a critical human rights-based study of evidence assessment, providing perspective on harmonization of procedural rules regarding evidence assessment, and moreover, adopting a forward-looking approach to evidence assessment. Now, I have to be honest, forward-looking approach is always such a appealing word to researchers and so on. Basically, what I mean by this is to try, after that I have analyzed the findings of my research, to try to put forward some sort of, let's say, guidance on how the problem that I've tackled with my research could be not solved, but at least dealt with. So in this sense, I intend a forward-looking approach. The research questions that I have elaborated so far are 4. They may seem a lot, but in the end, as I will explain in the next slide, it's more an exercise for me to try to break down the different steps of my research. So the first one would be what are the standards related to burden of proof, standard of proof, types of evidence, and threshold of credibility in the context of asylum claims based on sexual orientation, gender identity. Then, how is this law of evidence implemented in sexuality-based claims in the European Union? Then, how can the assessment of evidence be framed in order to respect and promote asylum seekers' human rights? And finally, in order to put these arguments in the context of the common European asylum system, the question would be, is there a need to promote harmonization of procedural rules regarding evidence assessment in the context of the common European asylum system? And if this is the case, how this can be achieved? So let's say this last question would be more, would go beyond the topic of LGBTI asylum seekers and would discuss the problem of evidence and procedural rules in the dimension of the European asylum system. So what I try to argue with my project is that first, evidence assessment in the context of sexual orientation, gender identity claims can be framed in a human rights-oriented manner, and this can accommodate both asylum seekers' rights to be treated fairly and to be protected, and also states' interest to assess who is entitled to international protection and who is not. Second, that the harmonization of EU procedural rules regarding evidence assessment can be achieved by reference to international law, particularly, of course, international refugee law, international human rights law, and as well as the principle of effectiveness in EU law. So this is something I'm still discussing with my supervisors, and I would like to explain you a bit of background, especially on the second point. At the beginning, I was not planning to concentrate on harmonization of procedural rules. This is something that came up after I was further reading and after I was discussing, especially with the doctoral committee in Leuven, which basically suggests to take into account this research in the broader context of the common European asylum system. At the beginning, the question that I was posing was, do we need the common European asylum system to have more rules on evidence assessment? Because apart from Article 4 of the Qualification Directive, there are no specific rules at EU level and also at the level of the Refugee Convention dealing specifically with evidence assessment. So the question was that. For the moment, I'm trying to see whether it's possible to, let's say, apply principles from international law, in particular, of course, refugee law and human rights law, in the context of evidence assessment, as well as the principle of effectiveness of EU law when it comes to procedural rules. So this is a work in progress, maybe. Regarding the theoretical framework, again, this is something that I'm still working on. The reason being that, as I said at the beginning, my project is supposed to be multidisciplinary. So even though my focus is, of course, international law and human rights law, I have to take into account also other disciplines, such as philosophy to some extent, or legal anthropology. My second supervisor is a legal anthropologist, so of course this, let's say, approach also the empirical perspective is well important. So for the moment, I see the importance to take into account principles and standards related to evidence assessment from a legal point of view. As I explained before, this would be like the first research question. Then human rights, in order to carry out, as I said, a human rights analysis of the topic. EU law, for what concerns in particular the principle of effectiveness. And finally, an intersectional approach that will allow me to take into account multiple, let's say, factors that could contribute to create discrimination and a situation of vulnerability for the person. For example, this is something that I saw also from the interviews that I was able to do so far. The fact that one person is a woman, lesbian, black woman, is important. It has a say, like the interconnection of these three elements plays a role indeed when it comes to also how to prove the claim. Other factors that can also be taken into account is, for example, religion, which I saw for the interviews that I've done so far plays a huge role in this kind of claims. For methodology is again one thing that researchers struggle a lot with. I will try to, of course, it's a qualitative study. I will try to combine a desk research approach and an empirical approach. For desk research, the first part of the thesis will be devoted to, let's say, conduct a sort of excursus from how sexual orientation and gender identity have made their way in refugee law, with, again, a specific focus on the European Union. I will, of course, take into account scholars' research, and I will conduct document analysis of legislation, and relevant case law, and I will explain later what I mean by case law. Since asylum is a matter that is decided, first of all, at national level, of course, the assessment of claims happens at national level, a comparative approach is necessary to this extent. For this reason, my focus would be on these four countries: Italy, Belgium, the UK, and Hungary. And I will explain why there is a question mark next to Hungary. So the reason why I would like to take into consideration these countries are because I was looking for one country that does not have any LGBTI-friendly legislation, and that would be Italy. Another country which instead has an LGBT-friendly legislation, that would be Belgium. A country that has guidelines on how to deal with LGBTI asylum claims, and that would be the case of the UK. And finally, a country which doesn't have any positive attitude towards LGBT issues and refugee issues, and that would be Hungary. Of course, the choice of the country is also motivated by access to resources, as you can guess, and also by language barriers. I can deal with French and English. Of course, my mother tongue is Italian. When it comes to Hungary, that will be like something that I will have to deal with. Maybe I will have to resort to an interpreter to have the case law translated. Let's say Hungary was not in my original plan. My original plan was only to focus on the first three countries. Again, this is something that came out when I was discussing my project first, as I said, in Leuven, and then when I presented my project at a doctoral seminar in January. And this is one part that maybe I would like your feedback on, because I understand that it's important to take into account one country that can be, let's say, the most different country in the context of the common European asylum system. So for the purpose of, let's say, drawing conclusions on harmonization in the context of the European system, it's important to take into consideration different countries that are nevertheless bound to the same rules. However, the problem that I see with Hungary is that, first of all, access to resources. I have contacts there, and I'm already in contact with some organizations there, but at the same time, previous research showed that there are very few claims regarding LGBTI asylum seekers, something like 5 or 6 if I'm not wrong. So of course that there should be something that I will have to take into account. Other EU countries, yes, may be considered as long as they can bring useful elements into the analysis, meaning that if there is like a case law that is particularly relevant for the subject of the thesis, it will be, of course, taken into account. For what concerns instead the other side of the methodology, the empirical research, as I mentioned before, I am conducting interviews. So at the beginning, when I was drafting this project, again, I didn't realize that I have 3 years. So I said, yeah, I'm going to do interviews with decision makers, judges, asylum seekers, refugees, NGOs, lawyers. No, because time is limited, resources are limited, of course. So for the moment, I'm focusing on interviews with asylum seekers and refugees. I'm also doing some, as I will explain later, I'm also doing some, let's say, participating in some meeting with NGOs. The problem that I see with judges and asylum officers so far is that it's very difficult to get access to them. At least in the UK, I've seen that the process is quite long. So what I'm trying to do now in order to, let's say, bypass this problem is to try to get in touch with judges who are retired. This will allow me to, let's say, skip all the process of asking for permission to interview judges and so on. In Italy, that it's easier because, as I said, I was working previously as a lawyer, so I have, let's say, my contact that I can mobilize, and I've already had the chance to do some, say, sort of preliminary interviews with judges. Lawyers, I thought it could have been easier at the beginning, but so far it was difficult to get in touch with solicitors and barristers, at least in the UK, because now, of course, I'm here in the UK, so I'm doing field work here. And it's very, I mean, to me, at least, it was very difficult to have a follow-up with them. Maybe at the beginning they are like responsive, but then when it comes to like the proper interview, it's a little bit difficult, so the process is a little bit slowed down. And then again, I would like to do, if possible, direct observation in courtrooms. Regarding the criteria according to which I will select, let's say, my samples and my cases, the purpose would be to be as inclusive as possible. The selection would be, let's say, guided to these 3 criteria. These are criteria that I elaborated at the very beginning of the study. So I will take into consideration both claims for refugee status and subsidiary protection, both accepted and rejected, because I think it's important to see how, let's say, the problem of evidence is dealt with in both cases of a successful and unsuccessful claim. Then cases in which the claimants were supported by lawyers and or NGS, at least in some part of the procedure. And then application presented or decided after 2004, when the first version of the qualification directive was approved. This is, again, a criterion that I put at the very beginning, and so far, let's say, I included this criterion without knowing it, because all the people that I was able to approach so far had their claim, let's say, lodged or decided from, I think, 2008 onwards. Regarding the, let's say, the people that I want to target with the interviews, I will take into consideration different types of claimants, being them gay men, lesbian women, transgender person, bisexual. For the sorry, I forgot to include bisexual, but for the moment, I was, at least the UK, quite lucky to have all of them on board, and regardless of their country of origin. Asylum officers and judges will be identified through available case law or by means of indication from NGOs and lawyers. For the moment, actually, what I'm trying to do instead is to, yes, look at case law, but also try to, as I said, contact judges who are retired, at least in the UK. And finally, for NGOs and lawyers, I would interview those who have an expertise on LGBTI asylum seekers. So where I am so far, and we are approaching the conclusion of the presentation. This is like the nice side of the, of the part for me, because it actually allows me to see at what point I am. So I drafted the outline of the thesis that I think that I circulated in the material that I sent. Of course, it's a draft of the outline. It's still, again, as I said before, a work in progress, but at least it allows me to see where I can fit the different parts of the research. I'm finalizing a paper on the EU approach to LGBTI asylum claims vis-à-vis the UNHCR approach. I will present this paper in Rome, and the final paper is due in June. I circulated that as well. I've written that with a colleague of mine. I'm writing the historical part of the thesis. Let's say I'm working on writing the historical part of the thesis. That should be sent to my supervisor in summer. I'm working at the moment on a paper on the role of soft law instruments in the context of EU asylum law, with a specific focus on LGBTI claims. So this is what I'm doing in the office, let's say. For what concerns instead the empirical part, I draft a list of questions for asylum seekers, refugees, and lawyers and experts. I'm currently conducting interviews with asylum seekers, refugees in the UK. I have to say that it took me a long to get started. I came here in February, and I started interviews sort of 10 days ago, something like this. So it took a long, but now I'm seeing that the process is started, and hopefully it will continue like this. I had the opportunity to participate in court hearings, but two of them unfortunately were adjourned. So I hope that I will have the opportunity to do that soon. And I'm participating in NGOs meetings. So basically what I'm doing is to go to these meetings of these NGOs and observing how they are, let's say, giving suggestion and advice to LGBTI asylum seekers. I was in an interesting meeting last week that was basically, the NGO was giving information to asylum seekers on how to prove their claim. So that was, of course, interesting from my perspective. And finally, not to flatter you, but just to really let you explain why I decided to come to Liverpool from Pisa. So, of course, the first reason that for which I decided to come to Liverpool was that I was looking for someone who with expertise on my topic, which is not that easy, of course, because as you may understand, it's, let's say, quite a specific topic. So in Europe, for my knowledge, there were two lecturers. One is Professor Spekerboy in Amsterdam, and the other one is Nuno, Dr. Ferreira. Of course, for my, I read an article by Nuno Ferreira, and I was suggested by my professor in Sant'Anna to contact him, and the collaboration has been so far fruitful. Another reason is that I also need to do field work in the UK, so that was like an additional reason to come here. Moreover, I have access to the library, and this is, of course, particularly important for me. I like the unit. It's a unit on international law and human rights, so of course, it's like my background. As I said, specific expertise on my topic, logistics, because I have an office, so that's perfect. And moreover, the possibility to conduct field work. Of course, at the beginning, all of my contacts were in London, so sometimes I have to travel, more than sometimes, I have to travel from Liverpool to London, but nevertheless, it will be easier than traveling from Italy to the UK, of course. So that's the reason why, in the end, I decided to come to Liverpool. And, and moreover, I will be in Liverpool until the end of June, because I asked for an extension, since it took me, as I said, a bit to get started with the interviews. To conclude, the open issues that I see so far, some of them I have already highlighted during the presentation. Selection of countries. I would like to talk a bit about this. So as I said, I think that I made clear why Hungary to me is still like puzzling. On the other hand, another idea was to take out Belgium. because since I was looking for, let's say, countries, as I said, one that doesn't have LGBT-friendly legislation, another one that has, the UK could satisfy both the requirements of being a country with LGBTI-friendly legislation and at the same time of having guidelines on how to deal with LGBTI asylum claims. So Belgium, for this reason, at the moment, I don't see like any strong reason to keep Belgium, apart from the fact that Belgium, together with Norway, is a country that collects statistics on LGBTI asylum seekers. So this is not, let's say, directly relevant for my topic, it is true, but at the same time, it may maybe signify that there is a sort of, let's say, attention for the topic. I will be in Belgium next year, probably also at the end of this year, for the joint doctoral program, and maybe it will be worth to explore also Belgium as a country. I have one, let's say, several definition problems, but let's say I took one here. That is culture. One of the main things that came out from the interviews that you can also see from the literature on this topic is that culture plays a role when it comes to the assessment of LGBTI claims. It is in fact claimed that the assessment of these claims is stereotypes, it follows stereotypes, and that there is a sort of, let's say, cultural clash between the examiner and the person who's sitting and asking and claiming asylum. Of course, how to define culture, it's not straightforward, and how it can be traced in the legal reasoning. Of course, it's something that can came out from the interviews, and so far it has came out, but on the other hand, how it can be, let's say, exactly traced in the legal reasoning and in the case law. Moreover, one problem that was highlighted, especially when I discussed the project in Leuven, was access to vetting decisions, meaning decisions of, for example, in the UK, the Home Office, of the Territorial Commission in Italy. On the one hand, it can be a problem because, of course, having access to those kind of decisions would have, of course, will complete the analysis, would give me like a more comprehensive overview on the topic. But on the other hand, especially when it comes to Italy, the decisions by the Territorial Commission are not motivated, so I won't get like many details in the end. Access to interviewees, as I said, it was difficult and it's still difficult. Honestly, it's more difficult, at least for my experience, to get access to, again, lawyers and judges. Honestly, what I've seen so far is that with asylum seekers, it took a bit to get in touch with them because you have to pass through NGOs and so on. But then once I have access to them, it's easy to, well, not easy, but it's feasible to speak to them. Most of them are really interested in the research. They are also willing to speak because sometimes they also think that you can do something like immediately for them. You can really help them. In Italy, it's easy also to have access to interviewees because I'm volunteering for an NGO which provides free legal aid to LGBT migrants. So let's say this is good, of course. Finally, times and resources, like I think this is a problem of all researchers, because once you research on one topic, you get more and more interested into that, so you would like to research even and even more, but there is time to consider. My thesis is supposed to be defended by May 2018, so of course, like, I don't have a lifetime, and as I said, everyone has its own drama because it's a path that I decided to undertake that I really like. It is challenging because I'm a curious person, so I like to study, I like to research more and more, but at a certain moment, you need to make a decision. So this is why I have still, I would say, many open issues in my research. So that was it on my side, and I hope that it was somewhat interesting for you. And as I said, I welcome any feedback and suggestions from you.
Thank you very much. Thank you, Denise, for giving a great overview of your research project. I think what we'll do now is we'll move on to some questions or comments, or maybe even some discussion as well on the topic in general. If you have any questions, comments, or would like to open the discussion, let me know and I'll pass the microphone over to you. If you could also introduce yourself as well, that'd be great. So does anyone have any questions or comments first of all? Yeah.
Hi, I'm Jo Bazzano from the Law Clinic. You touched on at the beginning the sort of current situation with refugees in Europe, but from your research, what sort of proportion of the people that you've interviewed have been asylum seekers who come through that sort of route, travelling through Europe and in lorries and that sort of route, or the other people who come maybe as students or on work visas and make a claim sur place in the UK?
Okay, so I would say that there is, at least for what I've seen so far, there is a difference from the people that I interviewed in the UK and the people that I interviewed in Italy. So I would start with that. In Italy, also due to the activity that I'm doing with the NGO, with Migrabo, I would say many of them, and when I say maybe many, I don't refer to like a huge number, of course. Let's say most of them came through Libya. So they actually came by boat, especially people from Nigeria. Yes, people from Nigeria, I would say, and also from Gambia. In the UK, the ones that I interviewed so far, a good part of them were students that were actually trying to come here as students, but then with the intention to escape from the situation in country of origins. Because I think that this, let's say, my answer to your question would be linked also to the kind of information that people have on the possibility to claim asylum. From the interviews that I've done so far, let's say, and from my previous experience as lawyer, people are not aware of the possibility to actually claim asylum, to come to a country and claim asylum. So, for example, I was speaking a couple of days ago with one young man from Nigeria, and he told me that when he arrived at the Heathrow airport, he was asked whether he wanted to claim asylum, but he said, I was seeing on the internet news of people being sent back in Europe, so I said that I didn't want to claim asylum, and that for him, of course, was worse because he was sent to the detention center. And so I would say that it's related to the kind of information that they have. So for this reason, maybe they come, most of them, with a student visa. And also, again, in the UK, they were either like students or already working in the UK, and then they went back to the country of origin. And for example, one woman told me, I had already a relationship with a woman in the UK. So when I came back to the country of origin, this news was made public, and I could not stay there anymore. So she came here and she claimed asylum because in the meanwhile, her permit to stay expired. So for the very moment, I would say that there is a differentiation also, I would say, for Italy and the UK, and also the way that people enter into Italy. Yes.
Thank you. Any other questions? You could pass it to Harriet.
Okay, I wanted to ask you about this paradox of evidence that you started with. And I was just wondering if you could explain this idea of the paradox a little bit more, because as I understood it, you had on one side that the evidence was used to establish a genuine need for protection, and on the other side, it was almost used as sort of a protection from refoulement. But I wonder if they're actually the same thing, and that in both cases the evidence is used to establish a need of protection, but the content of that protection depends on how much evidence you can introduce. So if you can just introduce enough evidence to prove that you're at risk of serious harm, then you can't be removed. But if you can introduce evidence that you're being persecuted on the grounds of the convention reason, then you can get full refugee protection. So I was wondering if you could explain to me how this paradox sort of works, because I can't quite see it at the moment.
Yeah. Should I pass back up or? Okay. Hiya. My name is Iris Lyman, second year law with criminology at Liverpool. I think you sort of already answered this a little bit, but this sort of two-part question that relate. So why do you think that it took so long to get into contact with the people you were interviewing in the UK? And do you think that was just because sort of the general process of how you go about doing that, or because of the specific subject matter that you were doing it? And then the second part to that question was, if you do get around to doing interviews in Hungary, how do you think that you'd go about doing that, and just the process of that compared to the UK? Yeah. Should I give it back?
I'll let you take that.
So I will start first with your question, and I will go back to yours. So I don't think that it was linked to the specific topic, honestly. At least for my experience, that I think that this specific topic was a reason why I was able in the end to get like several people on board, and also to get good interviews, because of course one thing is to do just an interview when you get a yes or no as an answer, and on the other hand, instead you have like a good interview where people are like actually also, some of them also suggested me some more questions that I should introduce, and they were really, again, interesting what I was doing, because they basically see the research as a way to make the problem public. So I don't think it was linked to the problem. I think it was more just a problem that with lawyers, they are busy. And if I put myself in their shoes, I would say that it's totally understandable. Again, maybe one problem that you can find with asylum seekers and refugees in general is also the problem of informed consent. So you need to guarantee them, of course, confidentiality and anonymity. My research has been approved by the ethics committee of KU Leuven in Belgium. We don't have an ethics committee for Sant'Anna. So, of course, it took me, something that I forgot to mention, is that it took me some time also to get the approval from the ethics committee, because there are like deadlines that you have to, for you to present your project. So it is more maybe, let's say, a problem also to arrange a schedule, basically. I had to go to London, so, but I wouldn't think that is close to, is due to the topic. And for Hungary instead, that's a very good question. That's why I'm a little bit puzzled whether I should take into consideration Hungary. My thought today is that I want to be able to do interviews in Hungary with asylum seekers and refugees. Also because if some of them were granted maybe refugee status, probably they already left the country, maybe they are living somewhere else, but just my assumption, I don't know. For the moment, I am in touch with NGOs and with one law firm. And if I can get interviews from them and have access to case law, I think that would be a good result. And if I can do also interviews, that would be wonderful, honestly. But it's a problem that I will try to deal with around October, November. So thank you. And for the paradox of evidence, maybe, so let's say so. I totally get your point, and I do agree with you to a certain extent. What probably I was not able to explain sufficiently is that, let's say, many times people are not able to support their claims with, let's say, a consistent set of evidence. Sometimes they just have their accounts, and that should be enough, let's say. But of course, it needed to be supported. So I see the paradox in this sense. One person that is believed to be, let's say, persecuted would be the one who is able to give a consistent account on his experience, and this is credible, and this is supported by evidence. On the other hand, many times people are not in the possibility to produce this kind of evidence. So in this sense, I see, let's say, a paradox. And also, to a certain extent, this goes back also to my previous research. My previous research, I will open like a small point on this. My previous research was focusing on the use of body in migration control, and I examined the case of age assessment for unaccompanied migrant children in Belgium. So in that case, the argument was mainly that we resort to age assessment even when it's not necessary, because it's like the best proof that you can get of your account that you are an accompanied migrant child, and so on. So it goes back to, let's say, the interest of the state to control who's entering and to also make it difficult to some extent to someone to prove why they want to claim international protection. On the other hand, the person who sometimes doesn't have means to prove this. So in this sense, I see the paradox of evidence. You need to support your claim. Also, let's say, beyond that will be the likelihood of risk that is required by the Refugee Convention, vis-a-vis the person that in many cases doesn't have the possibility to do so. And this is also why when I speak about the law of evidence, I try to break down that in 4 elements, because I think it's important to analyze how, for example, the burden of proof is applied in practice, vis-a-vis the international standards, how the standard of proof is implemented. Because, of course, according to the Refugee Convention, you have the likelihood of risk, but in several cases, the threshold is set higher. I don't know if I answered your question. So, thank you.
Thank you. I think I'll send this right up to the back to start with.
Hello. Yes, can you hear? Yes. So thank you for the interesting talk. To be honest, my name is Jafar. I'm a LLM student here at the university. I have 2 questions. The first one is what is the percentage from as far as your research is going now? What's the percentage of succeeding on these kind of claims? Is it quite high or low? And the second one, do you think that in terms of the main purpose, so it's not the main purpose, but in considering the asylum seekers and in comparing someone with being oppression by the government for more breaches of rights or other fundamental rights, is it equal for the LGBT rights as well? Accepting, of course, the 5 countries that penalize this death penalty, that give them the death penalty. So other than these 5 countries, do you think that all these other countries would have the same or should have the same equal standards with other people asking for asylum? So I'm wondering that if you consider the asylum seekers and how they are oppressed and they're coming from countries oppressed, in considering other main rights in their life, whatever torture or any other right, do you consider this other right or coming to seek this right is equal to the right of asking for asylum seeker for LGBT? Of course, minding the mind that the state will not be able to host everyone just coming for asylum. There's a proportionality test that need to be considered. Thank you.
Hi, hello. I'm Jennifer New. I'm a PhD student in sociology. It's actually not a question, it's more of a reflection on what evidence is acceptable. So you've spoken quite a little bit about it in your presentation, but it's just a bit of a reflection on my research in that a lot of people I've spoken to haven't actually known what evidence they can provide. First of all, you've already kind of said that people can't submit the same form of evidence, so they don't necessarily have the evidence to provide. But in terms of actually knowing what they can provide, there's very little kind of emphasis on that from, in my experience anyway, from legal professionals. The information comes from NGOs and small groups who are actually saying, okay, this is what evidence you can provide. This is the way you can provide it without being sexually explicit, which is decision makers. That's what they ask for, which is ridiculous. So it's more of a reflection on not only it's more a reflection on the evidence and, you know what I mean? What information they get about the evidence they can provide, if that makes sense. So think about that.
Can I have one question? My name is Qiang Ren, and I'm a PhD student in law school. But my area is international investment law, not in your area. But I have one question, just a general question. So you choose some countries like the UK, Belgium, something like that. But I think in terms of the refugee acceptance, I think Germany is a big country to accept that refugees, but you didn't choose that country. So can I know the reason? Is it just because the language issues or something like that? Okay, thank you.
Thank you. Okay, so we have quite a few questions there. I'll let you go through them.
So let's see. I will start with your question on Germany. It was not a language issue, the reason why I decided not to take into account. I don't speak German. I can read a bit of Dutch, and that's more than it. And moreover, my supervisor kindly offered to translate case law, so that would be the perfect idea. The reason why I didn't get I didn't decide to take Germany was mainly because when I, when I established the criteria, as I said before, LGBT-friendly country, non-LGBT-friendly country, and so on, I chose the ones, let's say, that were more, they were closer to me, honestly. And in this sense, of course, language plays a role. It's not the main language why I decided to take out Germany. When I meant that if there are case law of EU countries that are particularly interesting to be taken into account, of course, I will also refer to Germany, because Germany has an interesting case law for what concern especially the interpretation of particular social group in the convention. So in that case, of course, it will come. I won't focus on Germany because, of course, in that sense, so for the empirical research, language will play a role. But you made actually a very good point, because Germany is one of the few countries in Europe who's opening LGBTI-friendly shelters for asylum seekers, for example. So maybe Jennifer knows a bit more about that. But in Italy, we have so far, for my knowledge, but I think it's the only example of one reception center, which is in the region of Emilia-Romagna. But apart from that, I know that there are experiences in Berlin and so on. So it would be interesting to take into account. But when I decided to make a choice, that was the main reason why I decided not to take Germany into account. Yeah, thank you. But also, sorry, just add one point. Also, my supervisor told me at the beginning that maybe I should give a motivation of my country choices based also on of how many asylum seekers enter in the country, and we debated quite a lot on that. And Nuno also knows that. I'm not very sure of whether, of course, it was not your question, but I don't know whether taking into account the numbers of asylum seekers for this specific topic can be a good choice from a methodological point of view. So that's why I was inclined to say no. I would maybe see whether there are others qualitative factors that maybe can have a say for evidence assessment also. Regarding your questions on the rate of success, so far, at least in the UK, I would say 90% of the people that I interviewed were rejected by the Home Office and were then granted status by the Immigration Tribunal or by the Upper Immigration Tribunal. The case is different, at least for my knowledge and experience in Italy. Instead, where the people that I'm in contact with so far were granted asylum at the first stage with the Territorial Commission. Now, my thought on this is that not that Italy is, let's say, more able to assess this kind of claims, or we are particularly pro-asylum seekers. My thought is that we don't have any instruments on how to deal on LGBTI cases, and therefore, instead of having, let's say, an appeal to the decision, we, let's say, grant the benefit of doubt to the person. Moreover, Italy also grant asylum to people who come from countries where homosexuality is criminalized, even though the legislation is not enforced. So it just requires the criminalization of acts. Instead, other countries require both the criminalization and the actual enforcement. So maybe that can be an additional reason. But so far for the UK, I would say that the rate of success, at least with the Home Office, is very low. And also previous research showed that compared to other, let's say, grounds of persecution, when it comes to persecution based on sexual orientation, gender identity, these are claims that are more difficult. And this is another reason why I decided to take this as a topic, apart from other reasons, is that the problems that you have in this context with the evidence are like considered to be and are in fact more challenging than in other cases. And this allows me to answer to Jennifer's question. I totally understood your point, and maybe, it was a very good point, and maybe I didn't make it clear during the presentation, because it is true that asylum seekers, as I said before to Joe, they don't have any idea on how to claim asylum. They really don't know what is asylum. I think so far only one person told me that, yes, I was aware of asylum and what it is, but even that person didn't know what to bring to the Home Office and so on. So this is why when I break down the law of evidence concept, I include the types of evidence, because of course it can be difficult to retrieve, let's say, a letter of support from NGOs or LGBTI friendly legislation. It can be difficult to have witness statement. Another thing that I've seen so far that can make a difference is a report by an expert on either the country of origin of the person, on either the situation, even more specific, the situation of sexual minorities in that country of origin. So this is why I also would like to see which kind of evidence, because in my opinion, these elements, like the types of evidence, the burden of proof, the standard of proof, how we assess credibility, they can, let's say, they are it's up to member states to deal with this from a legal point of view, to establish rules in this sense. But it can nevertheless hinder the rights of asylum seekers when it comes to claim asylum. And especially it can also create inconsistencies among EU countries. Like if one country, only the account of the person is credible. For example, I was reading a couple of days ago a decision from a tribunal in Italy. This person didn't have anything to prove his claim, but nevertheless, since his account was deemed to be credible, was consistent, was well, let's say, exposed and so on, without any contradiction, he was granted asylum. Maybe in other cases, instead, it would have been needed to be supported by other grounds. So this is why types of evidence would be like a big part of my research, I think. And to conclude on your question regarding the violations of and the equality, let's say, of LGBTI asylum seekers, if I understood correctly, with other asylum seekers. So I would say that it's not a matter of equality. I understand your point, but at the same time, we have to consider that people who are fleeing their country of origin because of their identity, because of who they are, like in this case, for sexual orientation, gender identity, they are facing torture, for example. So they are not claiming asylum on the basis of torture. Torture is the result of what they get because of who they are, because of the, let's say, if we want to link it to the membership of a particular social group, because of of their sexual orientation, gender identity. The people that I spoke with so far, they really face everything, I would say, from torture. I'm assisting a young man from Nigeria in Italy, and he was burned, and he was fortunately, he was luckily rescued by a friend of him. They faced detention, and also, of course, there are cases in which they just face a risk of future persecution. So maybe they have, let's say, I'm sorry for this, just been, let's say, harassed and so on, or victims of hate speech. But this is my very personal opinion, when it comes to human rights violation, of course you have serious human rights violations, but they are all violations that are aimed at destroying the core of one person's identity. Another thing that I have seen for the moment from the interviews is that there is a sort of, let's say, competition among among asylum seekers themselves. For example, I've been told by a woman, I was refused because I'm a lesbian. And she showed me like the scars that she had on her arm and on her face. The Syrian woman who was living with me, just because she's Syrian, she got status. So of course that I think we have to be very careful in like dealing with this kind of matter, because it can be like a competition among people who really need help. On the other hand, it is true that resources are limited. It's like one principle of economy, but at the same time, we cannot make a sort of, let's say, competition among different human rights violations. But I do get your point, and this is why I wanted to include a slide on the relevance of the research, because not in the same terms, but there has been an argument, as I said before, that I've been heard a lot of times. So why are you focusing on that rather than like on people fleeing war and persecution? So yeah, thank you.
Okay, thank you very much. Any other final questions, comments, or points for discussion? Yeah, one more. Yeah. Oh, we have two.
I just wanted to ask, so in order to not lump together the LGBTI community, there's obviously the sexuality side to it, so gays, lesbians, bisexuals, and then there's the gender identity side, so transgender people, intersex, and then anyone who just doesn't identify with the norm. So would you say that, like, who would you say faces the most problems? Does that make sense? Yeah.
My questions, I guess, linked to your broader questions about harmonisation in the common European asylum system, and it's probably safer ground for me. But I was interested in how far you intend to push this. I gathered from the way you presented it that this is probably a question that you're going to come to a bit later in your research, as a way of sort of reflecting on the outcomes rather than something you're working on right now. But I just thought it's quite interesting to think about harmonization as, on one hand, it could be a way of sort of pursuing better standards, if you like. So, you know, you do your research, you come up with these ideas for evidence, you said for forward-looking conclusions. But then there's the sort of process that has to be gone through, the political process of the negotiation of legislation and the compromises and fights involved between countries like Hungary and Belgium, maybe. And I was just wondering how far down the rabbit hole you're intending to go with that. And it ties into this idea of, I guess, integration in the common European asylum system. And I was reading, I don't know if you've seen it, the Commission's most recent programme, and they're talking about having, potentially having asylum decisions at the EU level. And I just thought, it seems quite pie in the sky to me. I'd be very surprised if they get any agreement, but it does feel like that's the only sort of logically coherent solution. I mean, you've got decisions taking at administrative levels, judicial levels, completely different across the union, and it feels the only way you could really harmonise that is by having set rules, which is politically impossible. I just wondered if you'd grappled with these issues, you know, because I find these really interesting. I don't think there's a necessary answer here, but how far you've thought into that and how far you're going to push these issues in your research. Thank you.
So for your question, honestly, I don't know. So let's say it's quite difficult. No. So when I started the research, I was puzzled on using the LGBT acronym or LGBTI or LGBTQI. So for the moment, I'm using the LGBTI. I've been asked, why are you not including the Q? I've been asked why you include also intersex. It is something that I'm honestly thinking about still. For the moment, I've had the chance to speak only to one transgender person. And the questions that he was asked were more related to his homosexuality. I've had a chance to speak to 3 bisexual people, all of them men. And again, maybe it went back to the fact of being in a relationship with men again. So I don't know. I would say I also had the chance to speak to, let's say the majority of my interviewees are women from Africa. So I would say that, as I said before, the intersectionality of factors that can have, let's say, that create condition of vulnerability, I think it's very important. So I would say that maybe the most challenging and difficult cases, both for the people and also for officers to assess, are those where you have multiple elements to take into consideration. So yes, for example, ethnicity, gender, and also age sometimes can have a say. So I would say it's like more an interplay of different factors. This is why I think that the intersectional approach, that again, I didn't go through the intersectional approach because it's still something that I'm thinking of, and I hope that before leaving Liverpool we will have the chance to have another discussion, because it's an approach in a nutshell that was developed in the US as an approach to legal reasoning, to court decisions. So I would like to see whether it has a potential in this particular case, because I think that most of the time, also when it comes to information and what Jen was saying before, it's important, like, for to see who's the person that you have in front, like what that person has gone through, the possibility that she or he has to ask for information, to access legal assistance, and so on. So I would say it's more a combination of different factors. Yes. And I hope that I can tell you more later in June. So for your question, that's what I was discussing this morning with my supervisor, because so let's say at the very beginning when I started this project, it was okay. Harmonization means additional rules at the level of the Common European Asylum System. Then I said, I had the same doubts that you highlighted. Of course, it's also a political process. It requires integration, and how much it is feasible also in the present context of the refugee situation. So this is why I can just go back some slides. This is why now I'm seeing it more, I'm finding, let's say, ways in which harmonization could be achieved rather than creating additional rules. Okay, so this is why I'm mentioning the reference to international law, in particular international refugee law and human rights law, and also the principle of effectiveness in EU law. Because in my opinion, and this is something I will try to, let's say, test with the thesis, so I don't have a precise answer now, but my, let's say, understanding would be if these principles can be, regarding, of course, again, evidence, can be implemented and respected first and foremost at national level, there can be a way to reach, let's say, harmonized procedural rules. Of course, what I was discussing this morning with my supervisor is that the Court of Justice, because I mean these cases are likely to arrive at the Court of Justice. The Court of Justice has a quite a restrictive approach to international law. The Court of Justice is like the guardian of EU law. It's quite jealous of EU law, so it has a sort of autonomous approach even when it comes to asylum. So the court would be likely make a reference only to EU law, even though EU law should be, and especially asylum law, should be applied in compliance with international law standards. So this is why I'm also mentioning the principle of effectiveness in EU law, as also the jurisprudence of the Court of Justice says, member states have procedural autonomy, but their procedural rules should not hinder the rights that are guaranteed at EU level, and asylum law is one, of course it's a right guaranteed at EU level. So I would say that I will try, let's say, to move around this topic, seeing whether it would be possible to achieve harmonization in this sense. Another way could be to resort to soft law, instruments, such as, for example, guidelines by EASO, which would be supposed to work in order to foster harmonization among EU member states. So that can be another issue. But again, can soft law really play a role? And it can play a role, but to what extent? So I would say that, I don't know if I answer, but I would say that, yes, I'm trying to see whether using this approach could help.
Just quickly, I don't know if you've seen there's a recent case that came out earlier this year on, it was a Dutch asylum seeker who was sort of in and out of prison for looking at beforehand, but in the judgment they referred to UNHCR guidelines in the judgment, not just in the Attorney General's opinion for the first time. I don't know if you saw that case. I can't remember the names. I think it's like JN or JF. I'll check it and send it to you.
Okay, yes, thank you.
It's completely novel that it uses soft law UNHCR guidelines coming to the judgment and then
Yes, no, exactly. Of course, this is what I also told you, Nuno, before that I was discussing with my supervisor, is that, of course, even if you use, let's say, a bottom-up approach, and we try to apply, I mean, judges and authorities try to apply these standards at national level, but then when it comes to the Court of Justice, is like a problem for the attitude that the Court of Justice has towards international law. And it's interesting what you say, because I've recently discussed with a colleague of mine who was working on the role of the Court of Justice in the context of EU asylum law, and so that, like, even if the Court of Justice judgments say that EU law should be applied in conformity with international refugee law and so on, in the end, the court doesn't pay, like, let's say, attention to UNHCR interpretation and so on. This is also what we can see from the X, Y, and Z judgment on LGBTI asylum seekers. So for the moment, again, to finish up and answer to your question, I would say that I will see whether it's possible to use this approach to foster harmonization.
Okay, thank you very much. Any final questions or comments? No. Okay, thank you very much, everyone, for coming, and thank you again to Denise for giving your research and opinions. Thank you again.
Thank you.
There will be another lecture tomorrow by Judge Silvis from the European Court of Human Rights. That's part of the Human Rights and Security Forum. That'll take place tomorrow at 5 o'clock in the Leslie Henshaw Lecture Theatre. Everyone's welcome. And if you can't make it again, the event will be live streamed online. So thank you again, and thank you everyone for coming.